This is Annalisa Torres. I'd like to start by asking those who are listening in to mute yourselves. Counsel, would you make your appearances, please?
Good morning, Your Honor. This is Jorge Tenrero on behalf of the Securities and Exchange Commission. I'm joined by my colleagues Dugan Bliss, Daphne Waxman, and John Daniels.
Good morning, Your Honor. It's Andrew Seresny here on behalf of Ripple. Joined with me today is my colleagues from Debevoise and Plimpton, Mary Jo White, Lisa Zornberg, Joy Guo, and Chris Ford. Also, we have co-counsel on the line from Kellogg Hansen, Michael Kellogg, and Reed Feigl. We're all here.
Good morning, Your Honor. This is Marty Flumenbaum from Paul Weiss. We represent Chris Larson, and with me today on the phone is Mike Gertzman, Meredith Dearborn, and Christina Bunting.
And good morning, Your Honor. It's Matthew Solomon from Cleary Gottlieb representing Brad Garlinghouse. And with me on the telephone today are Noel Bamberger, my partner, Alex Jane Gerbani, Sam Levander, and Lucas Hackberg.
All right. I want to acknowledge the presence of certain listeners. We have a class of law students from Florida International University. They're taking a course titled Blockchain, Crypto, and Regulatory Considerations, which is led by Professor Mark Powers. For the benefit of the law students, I would like counsel for the Securities and Exchange Commission to summarize briefly why it is the SEC's contention that the form of digital asset or cryptocurrency sold by defendants is a security.
Thank you, Your Honor.
I will have the defense argue their position that it does not constitute a security.
Thank you again, Your Honor. This is Jorge Tenrero on behalf of the SEC. We allege in our complaint that the tokens sold by the defendants in this case, commonly known as XRP, were investment contracts, as that term is used in the Securities Act of 1933, and as that term has been defined by the Supreme Court in the seminal decision SEC versus Howey in 1946. Under the Howey test, the court looked at the economic reality into the representations that were made by the defendants in commerce with respect to the instrument that they were selling. The Supreme Court has instructed lower courts to look at the economic reality and whether we have an investment of money into a common enterprise from which investors were reasonably led to expect profits based upon the efforts of the defendants or the promoters. We allege in our complaint that this test is met because Ripple, the company, had most of the XRP in existence and offered and sold it in exchange for cash or other consideration, and reasonably led investors to expect profits based upon their efforts, their promised efforts to develop a quote-unquote use for XRP, or to develop what they sometimes refer to as the XRP ecosystem. The economic reality of this instrument is that purchasers are engaged in a common enterprise with each other and with Ripple, because the fortunes of the promoters and the investors lie together.
1 moment, please. I'm just going to remind our listeners that you must mute yourself. And Mr. Tenrero, if you would just go back a bit and continue.
Ma'am, as I was saying, the economic reality of an instrument like the one that is at issue in this case is that the fortunes of the investors and the promoters who still hold some of the tokens rise and fall together. And this is why, as we allege in our complaint, Ripple CEO at times described himself as being very, very long XRP, and why Ripple and its executives describes themselves as the parties most interested in the success of XRP. These types of statements under Howey, plus the economic reality, Your Honor, we contend, make it clear that XRP was offered and sold in commerce as an investment contract, Therefore, this offers and sales of XRP should have been registered with the SEC under Section 5, again, of the Securities Act of 1933, which is what we like to call sometimes the bedrock or the core principle, the founding principle of the securities law. And all that the SEC asks for in this case, Your Honor, is registration, which provides critical information to investors in the market that might decide to buy or invest their money in XRP. And I'd be glad to answer any additional questions.
I'm going to ask first to hear from counsel for Ripple Labs, and then I'll allow counsel for the individual defendants to respond if they would like.
Thank you, Your Honor. Andrew Seresny here. So we believe that XRP is not a security. Instead, it is a decentralized digital asset with fully developed use cases. We believe that for a number of reasons. First, both XRP and its underlying blockchain, the XRP ledger, have been fully functional for the past 8 years, with XRP trading in a robust market and listed on over 200 independent third-party exchanges. And Ripple plays a very small part in this market. In fact, in the past month, there have been over $66 billion in XRP transactions around the world. Second, XRP, we believe, is an asset, not an investment contract, and is a currency and not an investment contract. As we noted in our preliminary statement in our answer, the Department of Justice and FinCEN took a definitive position in 2015, which was reaffirmed actually just last year, that XRP is a currency, a convertible virtual currency. And in keeping with this conclusion, XRP is used in many use cases, including Ripple's on-demand liquidity product, but in other use cases as well. And it functions much like Bitcoin and Ether, which are two other digital assets that the SEC has publicly concluded are not securities, and therefore XRP should also be concluded not to be a security. I would note here that the SEC's international counterparts, including securities regulators in the UK, Japan, and Singapore, have already previously determined.
All right, one moment, Mr. Seresny. I'm going to remind those who are listening in to mute yourselves, and if you could just circle back and continue.
Sure. The SEC's international counterparts, securities regulators in the UK, in Japan, and Singapore, have already previously determined that XRP is a virtual currency and not subject to securities regulation. And the SEC, having waited 8 years now to determine that it's a security, is now the first regulator to allege that XRP is a security. Third, I would say that we do not believe the Howey test applies here because XRP is not an investment contract. It was sold as an asset. There was no contract with purchasers, no promise to purchasers that Ripple would exert efforts to support XRP. And applying the label investment contract and the Howey test to a situation where the buyer and seller of an asset are completely unaware of the other party's identity, we think would push the test past the breaking point. In fact, I should note that most of the sales of XRP were through programmatic sales in the secondary market, and those sales were aligned.
All right, one moment, please. I'm going to remind those who are listening in to mute yourselves so that I can hear Mr. Seresny. If you just go back to the beginning of your sentence, Mr. Seresny.
Sure. I would mention that many of the sales of XRP were programmatic sales into the secondary market to purchasers who had no idea that the counterparty was Ripple and to whom Ripple owed no obligations. And then there were also over-the-counter sales to purchasers who had agreements with Ripple, which were essentially purchase and sale agreements where Ripple did not agree to any future efforts. And so basically, from our perspective, the Howey test does not apply here because XRP is not an investment contract. But even if one were to apply the Howey test, we believe that Howey would not conclude that XRP is a security, and we believe that for a couple of important reasons. First, we do not think there was a common enterprise here between Ripple and XRP holders. There was no pooling of proceeds like you saw, for example, in recent matters in the Kin and in the Telegram cases, where the court concluded that, in fact, there was an investment contract because Howey was met here. In those cases, there was clear pooling of proceeds of sales of Kin and of Grams. In this case, there's no such pooling. Second, XRP's price is not primarily dependent on Ripple's efforts. And contrary to the SEC's allegations, the price of XRP moves in conjunction with other digital currencies such as Bitcoin and Ether, and not based on the efforts of Ripple. It does not move based on those efforts. And so, from our perspective, Your Honor, here in this case, unlike recent cases involving Telegram and Kik, it is clear that XRP is not an investment contract. I'll mention one other thing, which is we have a defense in this case, which is focused on whether the SEC has provided fair notice to the market that XRP is a security, and we believe that in this case there is clear evidence that there was substantial uncertainty about the SEC's interpretation of its own rules, particularly given that it was 8 years until the SEC brought this case while XRP was trading in the market, particularly given the 2015 DOJ and FinCEN determination that XRP was a currency, and particularly given that it has determined that Bitcoin and Ether are not securities. And in fact, just an example of this, we learned recently that in 2019, a cryptocurrency exchange met with the SEC staff specifically to share with the SEC their intent to list XRP in the exchange and to better understand how the SEC views XRP's legal status. And the upshot of that meeting was that the SEC did not inform the exchange of its view that XRP was a security. And in the absence of any clear guidance from the SEC, that currency exchange did its own analysis and concluded XRP was not a security and decided to list XRP. So for those reasons, we believe an additional defense here is that there was an absence of fair notice in the market that XRP would be determined to be a security. Thank you, Ron.
Would counsel for Mr. Larson like to be heard?
Your Honor, just very briefly, we agree with everything that Mr. Serezny said. With respect to the individuals, there's an additional count which accuses the individuals of aiding and abetting Ripple sales. And the standard for that sales require the SEC to prove that we knew or were reckless in not knowing that XRP was a security. And I think for the reasons that Mr. Serezny outlined, there is no way that the SEC can meet its burden on that extra knowledge fact with respect to aiding and abetting. And that's going to be one of the issues that we intend to raise in our motion to dismiss, which we mention in our letter to the court. That's all I need to say at this point, I think, Your Honor. Thank you.
And counsel for Mr. Bradley.
Yes, on behalf of Brad Gardlinghouse, it's Matt Solomon, Your Honor. I'll also be brief, although I'm going to speak a little bit more than my colleague, Mr. Flumenbaum, just did, just to clarify a couple of points. This case, as Mr. Serezny noted, falls completely outside of any reasonable Howey analysis. It's not shocking that it took the SEC years and years to make up its own mind about whether XRP was a security, but it isn't a security. The SEC's charges fail against the individuals for the same reason they fail against the company. XRP is not an investment contract. It never has been. In particular, as to the individuals, it's a gross overcharge because the SEC does not charge individuals in non-fraud cases absent significant aggravating circumstances, which are clearly not present here. This is not a fraud case. It's not pled as a fraud case. It's a Section 5 case. All other similarly litigated cases involve fraud charges. This will be the first the SEC litigates against individuals that don't involve fraud charges in the crypto space outside of one other case, Your Honor, that was simply a default case, so completely dissimilar. I would just also point out, Your Honor, that in addition to the aiding and abetting claim that the SEC brings against Mr. Gardlinghouse and Mr. Larson, which is effectively an effort to shoehorn a fraud-like claim into a strict liability offense, Section 5, the SEC has also failed to plead, as it must, that any of Mr. Garlinghouse's alleged sales were within the territorial scope of the U.S. securities laws. In fact, the amended complaint pleads the exact opposite. It says that the sales were made outside of the U.S. on worldwide digital asset trading platforms with counterparties all over the world. And again, Your Honor, the original complaint failed to plead any of Mr. Garlinghouse's transactions occurred on a domestic exchange. The SEC has now tried to cure that. In its first amended complaint, it's failed to do so, and all of the allegations are subject to dismissal on that basis alone. And in addition, again, on aiding and abetting, as Mr. Flumenbaum mentioned, the SEC's allegations establish the opposite of what they purport to do. Mr. Garlinghouse did not know or recklessly disregard that XRP could have been or was an investment contract. Of course, thousands, if not millions of others in the marketplace had that same view, including apparently the SEC up until very recently, Your Honor. And again, in terms of other allegations in the amended complaint against the individuals, they maintain that Mr. Garlinghouse, while he was Chief Operations Officer, gave substantial assistance to Ripple's violations. That's not true. They haven't pled it adequately. And again, as Your Honor will see from the motion that Mr. Garlinghouse has filed, that complaint, that aspect of the complaint is also subject to dismissal. The last point I would just say, Your Honor, just for the students' benefit, is there's active discovery in cases like this, and we've already taken some discovery of the Securities and Exchange Commission, which has already revealed that the Securities and Exchange Commission was having discussions with ultra-sophisticated market actors, including exchanges, and not apparently telling those actors that it believed XRP was a security or an investment contract as late as 2019. And again, as this case moves forward, these facts will come to light, and it will be clear that the SEC really cannot establish and will not establish that XRP was a security, an investment contract, and this entire case, again, is a gross overreach. Thank you, Your Honor.
I understand that Mr. Larson and Mr. Garlinghouse are contemplating filing a motion to dismiss the amended complaint. Is that correct?
That's correct, Your Honor. That's Mr. Flumenbaum speaking. We received the amended complaint on Thursday. We've reviewed it, and it doesn't change our position that the SEC has not sufficiently alleged aiding and abetting sales on domestic markets, and substantial assistance.
I understand that the SEC would not object to additional discovery after the court's decision on a motion to dismiss. Is that correct?
That is correct,
Your Honor. This is Jorge Tenrero on behalf of the SEC, Your Honor. That is correct. With the proviso, as we were in our letter, that the individual defendants have represented to us that they will participate in all discovery at present, and that no discovery that's permitted by the rules is off the table while the motions to dismiss is pending.
I'm going to be directing that the magistrate judge assigned to the case handle all pretrial discovery matters. And I will be uploading a case management plan today. Are there any questions?
Your Honor, this is Jorge Tenrero again on behalf of the SEC. I'd like to raise an additional point that's not raised in our letter that I discussed with Mr. Seresny last Friday, which is as follows. In terms of contemplated motions, the court's rules require the parties to anticipate for the court potential anticipated motions. One motion that we have contemplated or have come to contemplate since we filed the letter last Monday is potentially a motion to strike a defense. Mr. Seresny alluded to the defense as perhaps the due process or regulatory clarity defense. As Mr. Flumenbaum mentioned, we filed our amended complaint on Thursday. We have not had an occasion to speak with the defense as to what the plans are. It sounds like the individual defendants are when a move to when applying to move to dismiss, and Ripple might answer again or amend its answer. At that point, we would make a final determination as to whether we're going to move to strike that defense if it's still in there. But right now, we contemplate that is very likely to be the case, and so we wanted to alert the court simply because that was not mentioned in our letter.
Your Honor, this is Mr. Blumenbaum. One question for the court. We have determined that we will make our motion to dismiss, and I wanted to know whether the court wants us to still do the public letter to the SEC first. We've already, they amended their complaint after we sent the private letter, and we believe they haven't cured the deficiencies that they tried to cure. So the question is whether Your Honor wants us to file the public letter in accordance with your rules, or whether we can go straight to a motion to dismiss at this point.
Your Honor, this is if I may. Sorry.
Go ahead.
I apologize.
Go ahead.
I apologize, Your Honor. I was simply going to say that we found the private letter process helpful, and we would respectfully request, if the court is so inclined, that we do the public filed letters before the motions to dismiss.
Yes, the letters should be filed publicly. Anything further?
Yes, Your Honor. Andrew Seresny for Ripple. Just one thing in response to the SEC mentioning that they were planning on filing a motion, which they didn't flag in the letter to the court, but now have decided that they will likely make such a motion. I just wanted to note on that decision is probably driven in response to recent discussions we've had where we have sought discovery from the SEC regarding their internal dialogue and dialogue with third parties about whether XRP, as well as Bitcoin and Ether, were appropriately classified as securities. And so we assume that this motion is in part motivated to try to cut off discovery on those issues. We would just note that we think such discovery is relevant separate and apart from that defense. And we think it's directly relevant to a number of other issues in the case, including the individual scienter allegations, as well as allegations about whether XRP is an investment contract. So we'll continue on that issue to meet and confer with the SEC and see whether we can reach a resolution. But I would just note that there will very likely be a motion to compel, which I assume, as Your Honor just said, would be referred to the magistrate judge on the issue of discovery from the SEC.
All right then. That brings our conference to a close. I wish all of you good health. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor. XRP to the moon.